The court is in session in cause number 329824. The case is styled the state of Texas versus Jacob Wright or Jacob Perry Wright. Mr. Wright, is that your full name?
Yes, sir, it is.
Okay, how are you doing, Mr. Wright?
I'm doing excellent. How about yourself?
I'm doing fine, thanks for asking. Mr. Wright, you're represented in your case by your attorney, Glenn Crocker. Mr. Crocker, how are you doing?
I'm fine, thank you, Your Honor.
And the state is represented in this case by Mr. Lamar Johnson. Mr. Johnson, how are you doing?
I'm doing well, Your Honor. Thank you.
The court has before it a motion to modify conditions of community supervision. This motion was filed by Mr. Glenn Crocker on behalf of Mr. Jacob Wright. On October 14, 2022, the court held a hearing on this motion on November 4th of 2022. And the court, after listening to the evidence, the court took this matter under advisement. The court has reviewed the transcript. The court also is taking judicial notice of the paperwork that's in the court's file. And just, let's see, for the record, in Mr. Jacobs' motion, Mr. Jacobs stated that at that time that this motion was filed, he had served 6 months on probation, paid all fines, completed community supervision, completed all education classes, and followed all rules from probation. And he was requesting respectfully that this court modify the conditions of community supervision by removing the interlock device. Mrs. Jacobs' motion also stated that his grandparents lived in Uvalde, Texas, and he would like to be able to drive to visit them. The interlock goes off several times during his daily drive, and Mr. Wright thinks it would be unsafe to cause a 7-hour drive to be an all-day trip due to the nature of the interlock device. And the court held a hearing. At the hearing, Mr. Wright also stated that his, I guess his wife is expecting, and that they're supposed to have a baby, and that she has to have a C-section. He stated that if she goes off into labor at any time, he would have to jump in and haul her to the hospital. And so with being an interlock in his truck is going to make it kind of hard if she goes into labor because with a C-section, she has to have it stopped, and they have to be able to go in and emergency take the baby. He also stated that it would take a good minute once you run the breath through it and all of that, and it takes about a good 2 to 3 minutes to crank up the vehicle before you can drive it. And he's also stated that during his course of probation, when asked during the course of probation, have you had any issues with the interlock ignition device? And he stated not this one, the one that he currently have, but he had some problems with the previous one, but he had that one replaced, and now he has this one that he does not have any problems on. And the court, in looking at this motion, the court is aware that if a person is having a C-section is normally scheduled on a date certain for the persons to go in to have the C-section, and that schedule is scheduled in advance. It's not normally a scheduled emergency. The court also, in looking at this, considering the transcript, Mr. Jacob informed the court that if that if he had to go to Uvalde, which was a 6-hour trip, he said if he was to get there and it for some reason malfunction or something like that, he wouldn't be able to get back home to come back to work from his vacation. And he's also stated if it malfunctioned, it will go off periodically during the trip. And he says that if he leave out on Sunday night, it's going to be a late night trying to drive through heavy traffic with the thing periodically going off. It's not safe for you to hold a whole. The question was, is it safe? Is it safe to say that you don't have a whole lot of confidence in the device? And he said, no, sir. And he basically said it's a safety issue. In looking at the transcript, the court is considering the previous statements that even if he doesn't have a whole lot of confidence in the device, but that device that he's done have a whole lot of confidence on and has never malfunctioned. The previous device was that did malfunction was replaced by this one that has never malfunctioned. Regarding a safety issue, the court has considered the facts of the case, and considering the facts of the case, the court is aware that on the day in question of this incident, that Mr. Wright was driving a vehicle that left the roadway, struck fences of 3 residences, and while passing through the backyards of those residents. Also, the court is also aware that when the officer arrived, he observed that Mr. Wright was asleep behind the wheel, and after performing a test to determine the amount of alcohol, blood alcohol concentration, the test was 0.233, which was almost 3 times the legal limit. Based on statements, based on the facts of this case, the court is going to deny the motion to modify because the court is of the opinion that the community safety is paramount and the community is safer with the interlock being in place, in that Mr. Wright have not had any incidents while this interlock has been on, which is continues to keep the community safe. So at this time, the motion to modify will be denied. Okay.
Thank you all.
Okay. So at this time, this motion will be denied. Mr. Wright, you're excused. You have a blessed day. And Mr. Crocker, you are excused as well, and you have a blessed day.
All right. Thank you, Your Honor.
Okay.